Hello and welcome to the third in this three-part series about patenting apps at the EPO. My name is Sam Jones and I'm a partner here at Gill Jennings Every, an IP law firm based in London and Munich. I am a UK and European patent attorney and I specialise in the protection of computer implemented inventions, including apps. So in this third part of this series of webinars, we're going to talk about real-life examples of app patents. So these are actual patents to apps granted by the European Patent Office. And then we're going to conclude by talking about framing of the invention, ways in which you can frame your invention so as to increase your chances of obtaining a granted patent from the EPO. So if we move on first to the real life examples of app patents, first of all, the first example is a screenshot sharing app. So basically this app shares a screenshot via some other app. The way the invention works is that when a screenshot capture operation is initiated, the app generates a preview of a screenshot and displays this on screen. The preview overlays other apps and can be dragged to a certain area of the screen within other apps to cause the screenshot to be shared via that app. So if we think of an example here, you could capture a screenshot and you'll have a preview, say, in the top left of the screen. You then go to, say, WhatsApp, go to a particular contact, and then you can drag the preview of the image to the message entry field within WhatsApp. When you release the image there, it will cause the screenshot to be shared with that contact. And the important thing, I think, with this app is that the preview is overlaid on other apps. So that means that the preview is always accessible to the user directly. It's always on screen, no matter which app the user is currently in. So they could be in WhatsApp, they could be in a text messaging app, could be in an email app. It doesn't matter. The preview is always displayed on the screen. And the reason I'm talking about that is that, in my opinion, patentability here was provided by the fact that the invention defines a user input mechanism that objectively improves the ease of sharing a screenshot. And the reason I think it's objective is that because the preview is overlaid on other apps, it's always directly accessible to the user, no matter what usage pattern they're performing, no matter what app they're currently using. And so this is an example of a group 5 invention. And if you go back to the first in this series of webinars, you'll be able to have a look at the 5 groups that I talked about there. Okay, so if we move on to the second example, this is music tempo selection. And the background to this is a music playing app that adjusts the music tempo according to a detected user movement, for example, their running speed. And the way the invention does this is that the music playing app uses a phone's accelerometer to determine the current exercise speed. And this information is then used to automatically select music with a complementary tempo for playback. So you can kind of imagine, an app, a music playing app where you're jogging with it, it's in your pocket, it's detecting your speed and it's selecting for you music that matches your current running speed. And I think here patentability was obtained because the invention defines a control mechanism, and specifically a control mechanism for a music playing function of a phone. And this control mechanism is objectively easier for the user to use while exercising. And this is because the user doesn't need to look at the user interface. They don't need to press any buttons or give any voice commands or anything like that while they're exercising. They just do their exercise and the app is automatically choosing the correct tempo for them for their music. So I think this is, and I thought about this for some time and I couldn't quite decide. And I think actually it may be an example of 2 different groups of patentable app inventions at the Patent Office. And that's group 1 or group 5 inventions. And if you go back to the first in this series of webinars, you'll be able to see the 5 groups talked about there. But group 1 is to do with control of a technical device. And, a phone is a technical device, and this is a control mechanism, in my opinion. So I think you could acknowledge patentability there. Or you could acknowledge patentability under a group 5, which is to do with user input mechanisms which objectively improve the ability for a user to control a phone or a tablet or something like that. And I think here the objectivity comes in because the app is automatically controlling the music. Okay, so now if we move on to example 3, and that's the reliable metronome. So the background to this, you've got an electronic metronome that is not disrupted by a transition to a lock screen on a phone or tablet. And the way the invention works is that when the user initiates a browser-based metronome, the browser generates an audio clip for the selected metronome instead of just playing the metronome audio itself. And it transfers responsibility for playing the audio clip to a separate audio playing app that is not disrupted by a lock screen transition. So you can imagine sort of the background to this invention is that browser-based metronomes tend to be interrupted by transition to a lock screen. So that could be that the browser's ability to continue playing the clip is stopped when the screen's locked, so the metronome is completely disabled. Or it could be that there's a disruption for a short amount of time in the playback of the metronome if it's being done by the browser when the lock screen is triggered. And of course, with a metronome, one of the key things about it is that the time between adjacent ticks remains constant. And so if there is a lengthening in the time between adjacent ticks, that's going to be problematic for the person using the metronome. So you can see how the invention solves this problem, because the separate app that is playing the metronome audio is not disrupted by a lock screen transition. So you will get continued playback throughout the transition to the lock screen and indeed afterwards. And so I think here that patentability here was acknowledged because the invention provides an improvement based on the understanding of the internal functioning of the phone, and specifically what the lock screen does, how it behaves with regard to operation of other apps, and specifically browsers on the phone. So I think this is an example of a group 3 invention. If you go back to the first in this 3-part series, you can have a look at that in more detail. The final example is what I've called Appdoctor. So the background to this is that it is an app for analyzing images of skin and detecting objects of medical relevance in those images, for example, skin lesions. The invention works by the user providing an image of skin to the app, which uses machine learning, specifically a support vector machine, to classify pixels of the image as part of an object of interest, for example, a lesion, or as background pixels, i.e. they're not part of an object of medical interest. And importantly here, the patent provides specific details of how the classification is performed. And so here, I think patentability was acknowledged because the invention performs technical processing on an image, and specifically it performs image classification, which is an example of a group 2 invention, according to the classification scheme established in the first of this 3-part series. So I think it's important to note here that initially the patentee sought to have quite a broad patent, which was directed to essentially an app receiving an image and then providing information about whether or not there's something of medical relevance in the image. And what the Patent Office said to that is, no, that's too broad, because we don't actually know how the app is identifying things of medical interest in the image. And they said, what you're going to need to do if you want the patent is you're going to need to narrow the scope of your patent so that it's actually restricted to the particular way in which your machine learning algorithm does the classification. And in the end, that's what the patentee did to get their patent granted. And I think that's worth knowing because, for 2 points, really. One, when you're preparing the patent application, you're going to need to put that level of detail into the application if you want to rely on it later. And 2, when you're thinking about whether or not you want to file the patent application, it's worth keeping in mind that all patent applications are published. And so any information that you put into it will become available to the public after 18 months from the filing date of the application. So you have to maybe think, is it worth us giving away that information? And if it isn't, well, then perhaps the best thing to do is, in fact, keep how your machine learning algorithm works secret and accept that it will either prevent you from applying for a patent or reduce the chance that you'll get one granted. Okay, so now let's move on to framing of the invention. This is all about how to frame your invention to improve your chance of getting a patent granted at the EPO. So I think that the principles for me here are that you don't want your patent application to trigger an exclusion in the examiner's mind. So it's important to frame your invention to make it easy for the examiner to see the further technical effect that they're looking for, because if they can find that, then they will think, okay, yes, I can see that this is a technical invention, and I can see that there is a further technical effect, and so there is an inventive step, and I can grant a patent. The EPO is very strict on added subject matter, which means that you can't add anything to your application after you've filed it. So this needs to be thought about at the application drafting stage. I think also this is quite a good sort of process for going through for kind of gating whether or not you're going to go ahead with a patent application, because if you're thinking about your app and you can't identify a further technical effect, then the app is probably not going to be found patentable. I think this exercise is useful also as a sort of screening criteria or a gating process to work out whether or not you do actually even want to go forward with the drafting of a patent application. So let's have a look at an example. So this is just a hypothetical app that I've come up with for the purposes of this discussion. And this hypothetical app is a wallpaper selection app, and the wallpaper is selected based on a user's mood. So under a first framing of this app, we could say that the app detects the user's mood and automatically sets a wallpaper image that the user will find complementary to their mood. And we could say here the improvement is that the user prefers their wallpaper. So let's assess this against the EPO's criteria. Firstly, this is a subjective improvement. The question is, will all users always prefer the wallpaper that's been selected? Probably not. So that's a problematic because the Patent Office likes to see objective improvements when they are looking for further technical effects. Secondly, this framing is quite light on technical details. For example, how does the app detect the user's mood? We haven't said that, we just say that it does. So that's something I'd be thinking about under this framing, because it's going to be the technical details ultimately that are going to be what gives this app the further technical effect that it needs in order to get a patent granted. Then finally, the improvement here that we're talking about, that is the user preferring the wallpaper, that's in an excluded field because the wallpaper is, of course, a presentation of information. It's not an element of a user interface that the user can interact with. It's by its very nature a passive component, just a display of an image. So that's not a great position for us to be in, because if we've got an improvement that sits in an excluded field, then the Patent Office is not going to acknowledge a further technical effect based on that. And that means that we're not going to get the inventive step that we need. So now let's think about a second way of framing this app. So it's exactly the same app, the wallpaper selection based on a user's mood. But let's frame it like this. We'll say that the app captures and processes an image of the user's face to classify the image according to a mood classification scheme. We then explain that the processing is performed and we in the following manner, and then we give details of how that's done, specific details perhaps about the classifier, how it's classifying, maybe about the type of image data that we are feeding in, perhaps even how the classifier was trained. So we're giving technical details there. And the improvement that we talk about here is that the app provides a better image classifier for the task of classifying an image according to a mood. So now if we have a look at this and compare it to the previous framing of the invention, firstly, wallpaper selection is no longer the focus of the invention. The focus is now on image classification, which is something that the Patent Office considers to be technical. The improvement is now objective and is obtainable for all users. And that is because the improved classification will occur irrespective of whether the user likes the image that is suggested. The mood of the user will be determined more accurately by the classifier no matter what the user thinks of the image that comes out at the end. So that's an improvement for us, because we're now talking about an objective improvement rather than a subjective improvement. Also, we now see that the improvement maps to group 2 inventions. And specifically, that's because the improvement is technical processing on a digital object, and specifically image processing. So that's another positive point, because we've moved away now from the presentation of information that we had under the first framing, and we've moved the improvement to image processing, which is something that the Patent Office considers technical. So hopefully that sort of relatively trivial example there illustrates how the importance of framing your app with the Patent Office's requirements in mind. And I find in practice that when you frame an app in a certain way, discussions with inventors will be more fruitful, because you can imagine under the first framing of this app, the inventors might well talk about the types of images that are being suggested and how they fit with the user's mood. Whereas under the second framing, you can imagine an inventor focusing a lot more on, for example, the details of the image classification algorithm. And it's those details that are likely to get us patentability here, rather than saying something like, we like to choose a beach scene for a user that seems to be a bit down at the moment. So I think it's a useful exercise, both from a patentability point of view and also from a preparing the application point of view, because I think it focuses discussions with inventors into those areas which are most likely to provide details that will contribute towards patentability. Okay, well, thank you very much for watching this webinar. If you'd like more information, please do have a look at our website. Send me an email at the address shown on the slide there, or connect with me on LinkedIn. And please do stay tuned for more sessions on both general and specific IP topics. Thank you for listening.